Okay, this video is for everyone, but I'm going to pay special attention to those of you who might think you don't need an estate plan because you, my friend, are mistaken. Everyone needs an estate plan, young or old, rich or poor, it doesn't matter. Today, I'm answering the most common estate planning questions. So let's dive in and get your house in order. Now, the first obvious question is, what is an estate plan? What is estate planning? Simply put, an estate plan is your written plan for what happens when you die or become incapacitated. It's not just about writing a will to plan for your stuff. It's more than that. It covers not only who receives your assets and possessions, but also what medical treatment you prefer if you can't make decisions for yourself and who can act on your behalf if you become incapacitated. It may even include setting up a trust or choosing guardians for your kids if you have them. So it's essentially your playbook for life's unexpected twists and turns. Question 2, why should I care about estate planning if I'm not wealthy? You may think, what would I even put in my will? My iPhone? I have nothing. But even if your estate consists of a used car and maybe a small savings account, those are assets you've worked hard for. An estate plan ensures that your assets, no matter how modest, are distributed and managed the way you want them to be. Because without a plan, you're leaving your legacy to the winds of state laws and potentially messy family disputes. And you'd be surprised how small of an estate can cause family disputes after you depart, sadly. The other thing is, estate planning isn't just about possessions. It also includes your medical care decisions and your end-of-life wishes, even the guardianship of your children if you have them. So it's super important stuff. You should be the one making these decisions for yourself, and the only way to have control over those issues is with a written estate plan. Question 3, what are the essential components of an estate plan? When most people think of an estate plan, they probably think of, if they think of an estate plan at all, they probably think of a will and that's it. But that's just one part. A comprehensive plan also includes a durable power of attorney, which appoints someone to manage your finances if you're unable. It includes a healthcare proxy or medical power of attorney, designating someone to make medical decisions for you. Then there's the living will, which details your end-of-life care preferences. You might also want to consider a revocable living trust to avoid or minimize probate. So those are the essential components of an estate plan. Of course, there's much more you can add, but those are the main components of a typical estate plan. Question 4, what's the difference between a trust and a will? I'm so glad you asked. A will is a basic document that outlines who gets what when you die. A trust, on the other hand, is a bit more involved. It looks just like a stack of papers, but under the laws of your state, it's actually a legal entity. And this entity holds your assets while you're alive and sets the rules for the distribution of your assets after you pass. One advantage of a trust is that it avoids or minimizes the probate process, which can be long and expensive. Also, a will becomes public record, but a trust remains private. So each has its merits, but trusts offer more control and privacy, though they can be more complex and expensive to set up. Question 5, do I need a living will? Yes, a living will is a must-have if you want to say in your end-of-life care. It's not a pleasant topic, I know, but it's essential. This document outlines your wishes for life-sustaining treatments like ventilators or feeding tubes. It acts when you can't speak for yourself, ensuring your medical team and family are clear on your preferences. Imagine being in a medical crisis and leaving your family guessing or even arguing over what to do. That's what a living will aims to prevent. Question 6, is estate planning expensive? The cost varies based on your specific needs and the professional that you choose. Of course, online resources are available for simpler tasks, offering an affordable starting point, but to a certain extent, you get what you pay for. Legal advice tailored to your unique circumstances adds much more value. It actually does in this case. Ultimately, think of it as a safeguard for your assets and your medical and end-of-life wishes, and as peace of mind for your loved ones. Investing wisely in a solid estate plan can prevent legal and financial pitfalls in the long run. It's really not just a document, it's an investment in you and your family's future. Question 7, what happens if I die without a will? Dying without a will, also known as dying intestate, leaves the fate of your assets in the hands of state law. This could result in unexpected or unwanted heirs inheriting your property. For example, estranged family members could end up with a portion of your estate. The absence of a will also complicates the legal process, leading to higher costs and longer timelines for settling your estate. In worst case scenarios, it does even spark family disputes. They're a lot more likely when someone dies intestate. So a will ensures that your final wishes are respected and carried out. Question 8, how often should I update my estate plan? So don't think of an estate plan as a one and done type activity. As you go through life's highs and lows, like marriage, divorce, new kids, moving from state to state, your estate plan should evolve to reflect those changes. Every situation is different, but as a general rule of thumb, you might aim to review your plan every 3 to 5 years or after significant life events, whichever comes first. Failing to update your plan could mean it no longer aligns with your current wishes or legal requirements, which could lead to legal snafus. Always keep it current to avoid unintended consequences down the line. Question 9, what role does real estate play in estate planning? Real estate is often a cornerstone in anyone's asset portfolio. If you own property, deciding the fate of it in your estate plan is crucial. You have several options for that, and it really varies quite a bit state to state. You can bequeath it to heirs, you can sell it and distribute the proceeds, you can put it in a living trust or create deeds that transfer upon death. Again, depends on the state, and each choice comes with its own impact on other assets and its own tax consequences. So crafting a well thought out estate plan is crucial to make sure that your property is handled in a way that aligns with your wishes and that it avoids any unintended pitfalls. Question 10, can an attorney help with estate planning? An attorney doesn't just fill out forms. Actually, in this case, they really help guide you through a personalized plan, adapting it to your unique needs and circumstances. They can clarify state-specific laws and translate legalese into plain English, helping you make informed decisions. So while DIY options exist, the expertise of an attorney gives you peace of mind that your estate plan is both legally sound and fully aligned with your wishes. Okay, that wraps it up for today. Estate planning is not just for, members of Congress. It also is necessary for the young and maybe even the somewhat broke. So please make sure to take control of these decisions because these decisions should be yours. Feel free to reach out to us at Lyda Law Firm if you're in a state where we practice, and I'm wishing you the best of luck in planning for you and your family's future. Thanks for watching.